Would now call 126-747 State of Kansas versus Ervin.
May it please the court, Peter Meharry for Javan Ervin. If I could reserve 3 minutes of my time for rebuttal here.
3 minutes is Brandon.
Thank you. This case comes before this court after my client was convicted of several charges, including the most severe being a felony murder charge. He was ultimately sentenced to roughly 60 years to life. And we've raised several issues that we believe showed that he did not get his constitutionally mandated fair trial in this case. I'll start with the first issue in the brief, and that deals with prosecutorial error. In this case, in closing arguments, the prosecutor brought up twice the fact that my client had a prior fleeing and eluding charge. That's particularly important in this case because the underlying felony for the felony murder charge was a fleeing and eluding charge. However, we don't believe that there was an evidentiary basis. While this issue came up pre-trial and the district court had ruled that the fact my client had a prior fleeing and eluding charge could come in, it actually never did. It came out during the interrogation of my client by the police. However, that interrogation was never played. Instead, they had Officer Nadalzo testify, and when he was asked whether or not he was aware that Mr. Ervin had a prior fleeing and eluding charge, he said he was not. There was no other evidence to that fact. One of the cardinal rules for closing arguments is that your argument has to have an evidentiary basis. And so for that reason, there was none here, and it was improper for the state to argue it in closing arguments.
Don't we have to look at the next question and answer though, where the prosecutor refreshed the officer's memory?
But the next question was, were you aware he was on bond? It wasn't, were you aware he was on bond for fleeing and eluding?
But doesn't it all go together? I mean, isn't there enough of a question here or enough of an inference here to be drawn from the two questions in combination that it leaves at least the room for the inference that the driver was on bond?
I think it certainly,
eluding.
I think the only inference you can make is he was on bond for bond. You have to look at his actual answer. And I think to say there's an inference there, you have to ignore that answer where he says, no, I was not aware of it. The next question only talked about Javan Ervin being on bond and being concerned about getting in trouble for being on bond. It did not go beyond that. So I don't think you can make that leap to say, oh, it must have been bond for fleeing and eluding. And that's why we don't believe there is an evidentiary basis for the state then in closing arguments, bring that up to the jury.
But in terms of prejudice, it was the defense counsel brought it up in opening.
Defense counsel did bring it up in opening, but it's still prejudicial for the state to bring it up in closing arguments as part of its arguments as to why he should be convicted. We think that when you paint him, my client, Mr. Ervin, as a repeat offender, and not just that he has criminal history, but he has done what the state he is charging him to have done in this case. As I said before, the underlying felony here was fleeing and eluding. And you paint him as a repeat offender who apparently did it once. And certainly the jury would be thinking he must not have been punished for it because he's out there again. And we can't let him go this time. That's the prejudice we see. I'm sorry.
But isn't there an objection that could have been made, a valid objection, that the question itself, are you aware that he had a prior fleeing and eluding, that it assumes facts not in evidence? And that, which is, it presumes that he had this prior conviction and there was not such an objection. I mean, it's kind of analogous to asking somebody, how long have you been beating your wife? You know, that assumes you have been. And so you say, well, wait a minute, even though the question was for a length of time, it assumes facts that are not in evidence. That wasn't made. So can we make that assumption then that he was, that he did have a prior conviction for fleeing and eluding?
I don't think when you look at the question, I don't think it assumes facts and evidence, because it's literally asking, were you aware he had a prior fleeing and looting charge? I mean, that's not saying, when did you stop beating your wife? That's not that question assumes you're beating your wife. And the question is, when did you stop? Here, the question literally was, are you aware he had a prior fleeing and looting charge? So I don't think it assumes anything. And when he says no, we don't have an evidentiary basis to allow the state to bring it up in closing arguments.
But a prosecutor that's the rule. You have to have a good faith basis for asking the question. And that good faith basis was not challenged, was it?
No, it certainly wasn't challenged. This was an issue that was litigated pre-trial. But the fact that they asked the question doesn't mean when the witness says, no, I'm not aware of that they get to ignore the answer and then just make the argument in closing arguments. So that's why we believe it should not have been brought up in closing arguments by the state. And as I said before, we do think, given the facts and how the state charged this case, it was particularly prejudicial in this case. I would like to move on to a couple of the instructions that were not given, that were requested by the defense. We believe that those were important for the jury to be fully instructed on the law and how they should view the facts in light of the law they're given. Specifically, the defense asked for a definition of pursuit, and they also asked for a modification of the charge for murder 2, reckless second degree. They asked for those instructions, and the district court did not give them. It did not feel they were necessary. However, we believe that they were. In this case, the defense was not, my client didn't do it. Javan stipulated to being the driver that was involved in the accident that ultimately led to the death of another individual. His arguments at trial were more nuanced. His argument was that this is not the level of recklessness for reckless second. He basically conceded that this would be involuntary manslaughter, reckless involuntary manslaughter.
Can I ask you then, based on that stipulation, going back to the first issue and your prejudice argument, doesn't that sort of undercut that then? I mean, it almost seemed to me the prejudice argument was propensity, but if he's stipulating to being the driver, how would that prosecutorial comment be prejudicial?
He's stipulating to being the driver in this case, but I still think it's prejudicial when you bring in the fact that he has this prior fleeing and looting and you're painting him as a repeat offender, somebody who's done the exact same conduct in the past and is now doing it again. I think that pushes the jury to convict him, not necessarily because of all the evidence the state wants to point to, but because they're afraid of letting this guy go. So I don't think the fact that he stipulated to being the driver here undercuts the prejudice from being, as I said, characterized as a repeat offender. And going back to the instructions, the other argument at trial was that the pursuit had ended before the accident occurred. And the defense was, because the pursuit had ended, there was this gap between the pursuit, the accident, and ultimately the death, that felony murder doesn't fit. So it's important that the jury be fully and properly instructed on the law and how that plays in this case. And the defense asked for those additional instructions. Without getting those additional instructions, we don't believe that the defense had the ability to fully and completely present their defense so that the jury could take the facts and take the law and apply them and determine whether or not my client was guilty of the charges he faced.
The state argues that the way in which you added words to the definition of pursuit essentially was there to support your theory, but not necessarily to state the law. Can you address that criticism of your instruction?
I think the definition of pursuit did properly state the law. Defense counsel stated they got it from a Court of Appeals case, Escobar, which ultimately got it from Black's Law. And certainly, when you look at it and it states what they asked for, pursuit is the act of chasing to overtake or apprehend. Following is not chasing to overtake or apprehend. If the officers turned the emergency lights and sirens off, he was not in pursuit. I think that does accurately state the law, because it does show that to have pursuit, you have to have, and this goes to fleeing and eluding, you have to have lights and sirens. You have to have an officer actively pursuing with lights and sirens. And when that is done, the pursuit is done. And here, I don't think it's disputed that the officers had turned off their lights and sirens. The officers had turned around. So the pursuit is done, and it was necessary for that instruction to be included to clarify and make sure it was clear the jury understood when a pursuit takes place and when it does. When you look at,
I think your words and in framing that are interesting because you said, I think it's undisputed. Isn't that the problem with that last sentence, the way it's phrased? Doesn't it take away a factual question that might exist?
well, I say today, I think it's undisputed because I don't want to put words in the state's mouth. At trial and closing arguments, the state did say the lights and sirens were off. The officer had ceased to pursue my client. I use generally qualified language a lot of times here, but here from the trial record, the pursuit was done before the accident occurred. So that's why this instruction, this additional language within the instruction was necessary so that the defense could say, this is the law, and we believe this accurately states the law, and this is how it applies. It's not good enough to just say, well, you can argue this in closing. You know, when defendants claim self-defense, it only works if they get an instruction. If they get up there and argue self-defense without an instruction, it's meaningless. That's why these instructions are necessary for my client's defense. They're necessary so he can fully present that to the jury and fully argue those to the jury. The final thing I just, in my 20 seconds, I'll wrap up, is I do want to just say a couple things about cumulative error. Looking at how the prosecutorial error and the instructional issues kind of marry together to deny my client a fair trial. With the prosecutorial error, as I said, I believe that it's prejudicial to my client because it's painting him as this repeat offender who clearly hasn't learned his lesson, and the jury is going to hold that against him. So with that, you're undercutting my client, Mr. Ervin, at trial. Without giving the instructions that I've talked about, you're undercutting his ability to fully and completely present his defense. So at the same time, you're undercutting my client, you're undercutting his ability to give his defense. And combined, either individually or combined, we believe they denied him a fair trial. For those reasons, I would ask, as well as the ones in our brief, that this court reverse and remand this matter. Thank you.
May I ask a question?
Yes.
Concerning the cumulative error, you understand and you referred to our decision in Waldschmidt
Yes.
that if it's not clear error, it's not going to be included in the calculus under cumulative error. And could you you mentioned that one of the reasons for that is that the statute is less authority than the Constitution, which requires a fair trial. Can you relate that to the judge's duty to instruct appropriately?
Certainly, our position is, and I know Waldschmidt is relatively new, and this court has affirmed Waldschmidt since Waldschmidt. But our view is that a judge does have a duty. The statute says a judge shall instruct the jury. Judge has a duty to instruct the jury properly. And we believe if a judge fails in that duty, and that denies a client a fair trial, that is a constitutional issue. Constitution trumps everything, and that mandates a fair trial, and it mandates that this court look at every error in the trial. That is the basis of cumulative error. So we believe it may not be clearly erroneous, but it's still a legal error that occurred during the trial of my client. He has a constitutional right, as many courts have said, not to a perfect trial, but to, at the very minimum, a fair trial. And you can only determine that if you consider all the errors at trial. Errors work together, as I've argued in this case. They can play on each other, they can enhance each other. Whether or not that's an instructional error, a failure to instruct where the district court has a duty to instruct, or prosecutorial error in this case, or an evidentiary error. So we believe that it is important that when this court looks at cumulative error, which is a constitutional argument, that it has to include all errors at trial.
You said, I think I heard Constitution trumps evidence. Did you mean the Constitution trumps statute?
I have meant Constitution trumps everything. So. Thank you.
Thank you. Mr. Gillette?
Thank you, Your Honors, and may it please the court, Assistant District Attorney Lance Gillette on behalf of the state. I will briefly address defendant's claims that were argued here today, and with a little bit of hope, I can reach the final issue regarding some of our jail credit case law. First, the state wants to make one thing absolutely clear. We do not believe there was any prosecutorial error in this case because the record, when fairly construed, presented evidence that the defendant was indeed on bond or a prior flee and elude at the time that he committed the crimes in this case. It is very simple, very clear. At worst, at the weakest, when looking at this evidence, it was an absolutely fair inference that the prosecutor was allowed to draw. Record volume 21, page 147. Detective Naldoza was asked, I'll omit the lead up about housekeeping, but he was asked, are you aware that Mr. Ervin, at the time of the crash on July 6th, at the time of your interview, he had a prior pending felony flee and elude case? No, I was not aware of that. Okay, well, in his interview, does he describe, being on bond and not wanting to get in trouble because of that? And the detective answers yes, or yeah, he did. The prosecutor followed up, refreshed your memory there. It's been a couple of years. The detective agrees, yeah. It is the state's position, again, that if this is not direct evidence of the fact that the defendant was on bond, that the interpretation of the only reasonable interpretation, frankly, that can be drawn is that that was that the defendant was on bond for a prior flee and elude. And then in regards to how those then came up in closing arguments, and I'll tie this into the prejudice prong here as well. It was mentioned briefly twice. The prosecutor mentioned at one point that the defendant knew he was in trouble for a prior flee and elude, and then a little bit later on mentions he's on bond for a prior flee and elude. That's it. That was consistent with the state's position throughout this case. The history showed that both parties knew that the defendant was on bond for a prior flee and elude. They expected it to come into evidence, as was pointed out. The defense even mentions it in their opening statement. This testimony comes about, but then the trial is shortened. There is not any undue attention at all put upon this very narrow scope of very narrow piece of evidence that was only admitted for the narrow scope about defendant's mindset. We were not trying to paint Mr. Ervin as a repeat offender. It was simply to show that he knew what he was doing. And the limiting instruction was given that in conjunction with that and consistent with the party's intention.
What was the discussion on the limiting instruction? Was that insisted upon by Mr. Ervin's counsel?
Yes, it was insisted upon by both. There was a little bit of a
because there really wasn't a 6455 hearing per se, was there, prior to trial?
There was one. Okay. It was brief because everybody expected this to come in. Nobody really had a problem with it coming in.
Okay.
And then there was a joint request for a limiting instruction. There was only I believe there was one word that was disputed whether or not one of the purposes that it could have been considered for. But it was ultimately, a limiting instruction was indeed ultimately given.
Was the joint request was part of the instruction packet at instructions conference?
Yeah, it was a part of the instructions conference. I think it was part of the defendant's written instructions in this case, but I know it was part of the instructions conference.
And that would have happened before the evidence unfolded
No.
at trial?
No,
Or
that
did
came-
that happen after this exchange of testimony that you cited earlier in your presentation?
It came well after.
Well after.
It came after the conclusion of evidence in this case. So in addition to the state firmly believing that there was no prosecutorial error here, even assuming in some form or fashion that appropriately commenting on the evidence could be construed as error, and frankly, I understand that is basically the argument. There are interpretations that can be made about this evidence. The state's was fair. The defendant would ask that that wishes that there had been a different interpretation. That does not constitute prosecutorial error, nor was there any indication of prejudice here. On the two instruction issues, briefly, I'm going to start with pursuit first. I do want to make it clear that the defendant's requested instruction did indeed lack support almost at all, save the first sentence. There was an unpublished case cited where it was merely Black's Law Dictionary defining pursuit as, quote, the act of chasing to overtake or apprehend. That quotation, respectfully, from was obiter dictum or dicta in that case, as it wasn't necessary for the resolution of the case that it was cited in. But that's not the definition of pursuit that the defense have requested here. They asked for that sentence plus, quote, following is not chasing to overtake or apprehend. If the officer turned the emergency lights and sirens off, he was not in pursuit when the motor vehicle accident occurred. That's what was requested. Those instructions did not have a basis in the law. They did inappropriately emphasize the defendant's interpretation of the evidence, as continues to be reflected by the attempt on appeal to further parse out the steps and the seconds and moments in this case about when the pursuit started, when the reckless driving happened, when it ended, were there any intervening causes of the murder here. And respectfully, that instruction would not have been necessary because I think reasonable people can understand pursuit, nor would it have been appropriate due to its improper emphasis that would have given to the defendant's evidence in this case. On recklessness, that is a bit of a closer call. However, respectfully, the state still is not clear today. What exactly did the defendant want to be instructed upon as part of a reckless definition? Below, they pressed two different options: that the instruction be modified to read, a defendant acts recklessly when the defendant consciously disregards a substantial and unjustifiable risk that a result of the defendant's actions will follow, showing extreme indifference to the value of human life, or to somehow parse that out and separate it into two different lines and have the under circumstances phrase delineated as somehow a second element of the offense. Then now on appeal, they're suggesting that, quote, the conduct must show extreme indifference to the value of human life. The state maintains this is a subtle but meaningful difference. If the jury had been instructed that they could only focus on the conduct in determining whether or not this killing was reckless, that's not right. That's not a correct statement of law, because the correct statement of law through the long history on second-degree murder on this is clear that tiptoeing into these waters gets very muddy very quickly, because what's important is the circumstances in which the reckless conduct occurs. That's more than just the conduct. It takes into account the circumstances. That's what differentiates second-degree murder from a different layer of manslaughter. That is the muddy water that the court successfully avoided in this case by not entertaining and it entertained it, but it didn't grant defendant's request. So we agree, again, we maintain that there was not only no error, but that regardless of if there was any kind of error found, it has to be deemed harmless, regardless of what level of harmlessness review is applied. We would again, though, ask that clear error be applied to both. On the cumulative error, very briefly, the state again maintains there are no errors here to accumulate at all, period. There are none. There are no instructional errors that reach the level of clear error that could be included in the calculus. The cumulative error argument fails. If there are no other questions on those points, I would like to take just a little bit of.
Have a
Go ahead.
question. On the cumulative error analysis,
Yes.
under Waldschmidt, if there is no clear error, there is nothing to accumulate. But the duty to properly instruct is the courts. And so how does that relate to the constitutional right to a fair trial if we don't consider errors that we've found that were not clear error?
I think that the best answer that I can give is that while the district court does have a duty to properly instruct, clear error really embraces the concept of an instruction or a failure to instruct reaching a constitutional level of like a constitutional error. And it requires an error severe enough that it would reach or impugn a constitutional right in order for it to be accumulated in that analysis.
Let me ask you this then. Cumulative error of, let's say we have no clear errors, but we have 100 that are clear errors. And you're saying that even we should not consider the cumulative effect in deciding whether 100 non-clear errors can be considered to represent constitutionally an unfair trial. Never happens.
I think that, well, I don't know that in a case with over 100 individual errors happens, frankly, but
But if we follow the Waldschmidt rule, wouldn't you agree? We don't consider any of them when deciding whether there's been constitutionally an unfair trial. It's just,
that's correct.
nope, we're not going to think about it.
That's correct. Under Waldschmidt, that is correct. And that is the status of the law
Does
today.
that satisfy the Constitution?
I think that it would have to be identified, and if there's a need for further briefing on this point specifically, I mean, we would welcome that, but
Well,
I have to.
if an instruction is not clear error, is it error at all? Isn't that the rationale of Waldschmidt?
I think that is basically the underpinning of Waldschmidt. And so if it doesn't reach that level, it shouldn't be included in the calculus.
But it's clearly not correct.
Something may be not correct. Something may be not correct because the defendant wanted it to be not correct, or something may be incorrect because the parties agreed to do something for the sake of efficiency, or simply because they agreed. I mean, there are 100 reasons.
Can something be incorrect and yet not wrong?
Sure. I think the example I just gave about parties, I mean, agreeing to do something in a case, I struggle to find anything wrong with that, even if what they agreed to do is technically incorrect. I
But
guess
it's not the
there's certainly
parties-
nothing constitutional with that.
But it's not the party's duty to instruct, it's the court's duty.
That is correct.
And if we admit, and if inadmissible evidence gets admitted and there's no objection, that doesn't count either, does it?
No, it doesn't.
Just wanted to include you in the family discussion here.
But the court doesn't have the duty to submit evidence, correct? That's the party's clear duty.
But the court is the gatekeeper for evidence, and there can be instances where a court can preclude the admission of evidence, even if the parties try to admit it. Even if the parties tried to do so jointly, a court has the authority to preclude evidence in certain circumstances.
But if the court does it, it's reviewable, right?
I'm not certain. I think it would depend if the court does it at the party's whims, at the party's wishes, then it's not. It could be invited error. Briefly, if I could, just on the Hopkins issue, the state is not here to ask this court to reverse Hopkins, to find Hopkins is wrong, to find that there's necessarily anything wrong with Hopkins other than that it ought to be limited to its facts. I think that the Fikert decision that decided in the briefs from the Court of Appeals points out that Hopkins is noble. It has been the goal, I can state for this court, has been the goal clearly in this case, when you look at the journal entry and the guidance that was offered by the district court, was trying to do what Hopkins and the statutes want the parties to do, to make sure that the defendant is entitled to every day of jail credit to which he or she deserves, but not duplicate credit. There is no basis in the law at all for a defendant to be receiving duplicate credit, to reward multiple instances of bad behavior by double counting the time one spent in jail because their behavior has been so bad, makes no rational, logical sense either. We would simply ask that this court revisit the Hopkins guidance, offer some clarification based on cases where we don't have such a clean factual pattern as existed in Hopkins. We would ask this court to follow the reasoning in Fikert. I think that the statutory amendment further bolsters the state's position here, that amendment was undertaken to try to maintain or fill in a gap, I guess, that was left following Hopkins. And that gap is, what do we do when we have complex cases with recidivist offenders with multiple cases pending at the same time? If there are no further questions, I thank this court very much for its time. The state would respectfully request that all of the defendant's convictions and that his sentence be upheld, including the jail credit which he has received.
Before you sit down, can I ask, you made reference to the instruction conference about the limiting instruction?
Yes.
And do you have a citation where you would point us to? I pulled it up real quickly because my memory was that there was kind of an objection from the defense, and it does look like you could say that the defense counsel was really arguing about whether to include the word identity. But he gets interrupted several times as he said, do we even need to give this instruction? So I'm trying to, if you have a clear place where defense counsel asks for it.
Ask for
The limiting instruction. Because I thought that was what you said, that
I believe that he
the
did.
parties clearly did. And it does look like they had an email exchange about how to word it, which I guess you could infer from that. But anyway, if you have a record citation for that point.
I apologize that I don't write off, Your Honor.
Okay, we'll
I
just
just-
continue to look through that then. So,
In my brief, it looks like I cite record volume 22 is where at least part of the instruction conference occurred. But
and
I'm trying to recall, I felt like it occurred in two separate volumes here. It's
Okay.
escaping my mind or
I'm
citation
looking
right
at
now.
that volume, page 45 right now. So, okay, thank you.
Thank you.
Mr. Meharry, you reserve 3 minutes.
Couple quick points. With the limiting instruction, I think there was some discussion and some back and forth, as you said, about the language. I would also point out the instruction in the written request by the defense, and that's volume 2, page 149, does not have any language specifically to having a prior fleeing and elude. It only talks about having evidence has been admitted alleging the defendant committed a crime on a specific occasion other than the present crimes charged. So I think that the defense did have some issues with that, that I will admit the instruction conference, there was a lot of back and forth, so it's a little muddled.
Well, can you clarify for me, was there a pre-trial or during trial 6455 kind of discussion?
I believe there was, and I think this is the right. I may be wrong on this, but I think record 6, maybe there's some discussion. I've got pages 44 to 66. I believe there's a discussion about that. I think that's the right site. If not, I apologize. But this was brought up pre-trial. The district court did ultimately rule that it could come in, but as I've argued earlier, we don't believe the state actually did that when trial played out. The second thing, with regard to the reckless second instruction that was requested, and this is from volume 22, page 11. Defense attorney said, my suggestion is that at the end of the definition of recklessness, you add that language of showing extreme indifference to the value of human life. That's what I thought my argument was in my brief. I quoted it, so I'm not sure. I'm not following where the change is, but that's what was argued below, and that's what I've tried to argue here. One comment with regard to whether or not a clear error is an error, whether or not you can consider it, and we talk about, well, if there's no objection to an evidentiary issue, we don't consider it an error. I think those are apples and oranges. And I say that because when you have an evidentiary issue, it's not necessarily just a legal ruling. There's a lot of discretion that we give district courts. They look at prejudice versus probative value, stuff like that. So without an objection, without a record, I don't think you can say it was error or not. I think instructions are different. The court has a duty to properly instruct the jury, and this court can say, as a matter of law, this instruction was wrong, objection or not. So I think that is a difference, and that's why, even though it may not be clear error, the failure to properly instruct a jury is still an error at trial and still should be considered. The only other comment I would have with regard to Hopkins and everything, since they amended the statute. Why did they amend the statute? Because this language allows for double credit, and they sought to correct that. What the state wants you to do is say the amended statute is the same as the old statute, but it's not. There's a reason why they amended it. The statute that was in place at the time of this case just says you get jail time credit for the time spent incarcerated pending disposition, period. It's not qualified. State, with Campbell, this court added language to the statute. The state wants you to continue to do that. They fixed the problem, but the statute is clear, unambiguous, and that's what this court said in Hopkins. That's why, like it or not, I know the state doesn't, you get double credit here. Thank you.
Thank you to both counsel for your arguments today. The court will take this appeal under advisement.